All right, we're going to start on time since it's on the hour. I'm Jeff Youngren. I'm honored to be here to introduce Tess Neal as our speaker. I'm a clinical professor at the University of New Mexico in the Department of Psychiatry and Behavioral Sciences and the university in general, and have been involved with this program where we have a postdoc program in forensic psychology for the last 3.5 years. Let me introduce Tess to you. It is a little bit painful because she's an Arizona State faculty member and I'm an Arizona grad, so that the rivalry has been there since we started, but we'll forget that and I'll just go ahead and introduce her and say, read her bio. First, we really are privileged to have you here. It's a great program, but it's only made better by great presenters like you. So Tess is an associate professor of psychology at ASU, Arizona State University, a founding faculty member of ASU's Law and Behavioral Science Initiative, and principal investigator of the Clinical and Legal Judgment Lab. She is a scientist, a licensed clinical and forensic psychologist, and the parent of 2 young children. She studies the nature and limits of expertise. Her basic work focuses on understanding and improving human judgment processes, especially among trained experts, and her more applied work focuses on improving forensic experts' judgments in particular. Her work has been funded by multiple grants from the National Science Foundation, and she has been awarded numerous research and teaching awards. She serves as editor for the Journal of Personality Assessment and Psychology, Public Policy and the Law, and as an open science advisor for clinical psychological science. She was selected as a Fulbright Scholar to work in Australia in the spring of 2022, not a bad gig, on the project about how the different forensic psychological assessment evidence with the potential to inform revisions to laws governing the admissibility of expert evidence in both countries. So on behalf of the University of New Mexico, Tess, we're honored and privileged to have you. And now I'll turn this over to you.
Thank you so much. Can you hear me? Hopefully we're good. I am really happy to be here and so excited to be joining you guys. I've been a fan of this program for the 3.5 years that it's been going, and have been attending a bunch of these lectures and have been, just really, it's been nice to be able to hear from so many people around the world. And being able to do this online has been quite a privilege. So thank you to you guys for what you have built and for providing this kind of platform for people. Let me make sure my slides are working here. They are not moving forward. I'm going to stop sharing and reshare and see if that fixes it. Sorry. Sorry. Are you seeing my slide?
Looks good.
Okay, sorry about that.
Tess.
Okay, so I think you guys probably know how this works. At the end, we'll come back to this. There is a CE certificate process. Disclosure, we are declaring no conflicts of interest with regard to financial relationships here. The views are mine. They're not those of the University of New Mexico. The learning objectives today, we're going to try and hit all 3 of these. So I'm going to walk through with you some best practices to evaluate the rigor and value of a forensic psychological assessment. We're going to differentiate and think about the foundational validity of an assessment from the applied validity of an assessment. These ideas are not new, but the way we're kind of thinking through them and what we're bringing into this discussion from other areas of literature and of science is somewhat new in the conversation in forensic psychology to date. And those 2, foundational validity and applied validity, are 2 of the best practices. And when I just alluded to bringing in influences from other areas, these other areas include open science, forensic science, the judgment and decision-making literatures, and other literatures, kind of pulling from these different areas in thinking about how do you evaluate the rigor of a psychological assessment in a forensic context, and how do you do a rigorous evaluation. So we have a paper on this that is coming out now. This is the abstract to the paper. This particular presentation is a little more text heavy than I would like for it to be, but this is new and I haven't had the time to refine it into less text heavy. So I apologize for that, but the ideas are in here. So in this work, in the paper itself and what we're going to be talking about today, we review the state of forensic mental health assessment, and we are happy to know, and as you all know, the field is in much better shape than it was in the past, but we still have quite a number of problems with the quality of what we're offering, and there's room for improvement. So we are acknowledging both of those things are true. So we provide an overview in the paper. We're not going to do it in the presentation today, of kind of the history, and then we'll talk about the possible future with multiple audiences in mind. One of these audiences is a group like this, of us, the practitioners doing this work. So in this paper and in this presentation, we're distilling decades of scholarship from and about fundamental basic science, forensic science, clinical psychology, forensic psychology, and the law of expert evidence into 8 best practices for the validity of forensic psychological assessment. These ideas aren't new. Again, we haven't invented these things. We're just pulling them together in hopefully what is a useful way. And then this last sentence, we'll talk some about this, but our position, our argument here is that these best practices should apply when a psychological assessment relies on the norms, values, and esteem of science to inform legal processes. There are several collaborators who have helped with this and who are in spirit part of this presentation today. Christy Martiri is the main person who did this work with me. Christy Martiri is an associate professor of psychology at the University of New South Wales in Sydney, Australia. She's the person that I worked with over these past few months when I was on sabbatical in Australia, and it was so fabulous. The other people who have helped with this are Jen Johan, who is who's finished, but she was one of Christy's PhD students at UNSW. Elizabeth Mathers is one of my graduate students here at ASU. And then Randy Otto, who needs no introduction to this group. We were very lucky to have Randy join us in this project. The paper is a piece of a case that also is relevant and has some, I think, important pieces of the story of how this came to be. So I'm going to talk about that case as well. So the paper is relevant to this group. It's open access. We paid for that. We made sure that it would be free to anyone in perpetuity. It will be published, I think, in October, but it's up now. There's a draft up now on the Annual Review of Law and Social Science website. It's also on my website. It's on the PsyArchive. It's on the Open Science Framework. Like basically, if you look for this paper, you should be able to find it without a problem. The case side of it, Christy and I were involved in a big commission process that's unfolding in Canada. And there's a lot going on with that commission, but one piece of it was concerned about the quality of a particular psychological assessment in a legal context, and we were hired to evaluate its quality. So that's some of the motivation for this. In that process, we boiled a lot of stuff down into this, basically. These are the 8 best practices for forensic psychological assessment that we identified and that we'll talk about here today. Foundational validity, validity as applied, management and mitigation of bias, attention to quality assurance, appropriate communication of data, results, and opinion, explicit consideration of limitations and assumptions, weighing disagreements or alternative facts, and then adherence with ethics, ethical rules, codes of conduct, professional guideline, rules of evidence, and things like that. And then, as we note, we argue that these best practices should apply when a psychological assessment relies on the norms, values, and esteem of science to inform a legal process. So we're going to go into each of those in this presentation. But before we get there, I'm going to give you some background and other information. One of those things that I want to tell you about is a resource that we put together for anybody, for multiple audiences, again, us forensic practitioners as one of those audiences. This document, it's an Excel file, is posted on the Open Science Framework at this link. The OSF can be a little wonky to try and figure out, but I'm happy to help anybody who wants this get access to this if you want it. It's an Excel document where we tried to translate those 8 abstract ideas into concrete. What does this mean? What would you look for in a report to know whether it did that thing, whether that best practice was considered, dealt with, anything? How would you do it? How do you translate those ideas into concrete usefulness? Christy did the color coding on this, and she she loves it, and I think it looks nice too. But basically what this is it's a series of 117 questions, and they're kind of organized into 8 groups under each of these best practices. So for instance, best practice number 1, how was foundational validity established? If you click on the left side, there's little plus boxes. If you click the plus box, it opens up a bunch of questions that could be asked about a given forensic report. And that's the case for all of these best practices. We used this in the case that I mentioned to try and systematize our evaluation of the quality of the report in question. We used this coding scheme where we gave ourselves 0 to 3, not at all, to definitely applicable, not at all, somewhat definitely not applicable, or unable to code. In retrospect, I'm not sure that that's quite the right coding scheme, but it was a place to start. The way we have this posted online, it's the license for it it's free. So anybody who wants to use this could use it. We are not arguing that our 117 questions are exhaustive or that they're the right ones or that there couldn't be more. Also, it's not like this is a score that it's like 0 to 100% and they did it or they didn't. It's more like, what do you look for? What's the gist of the ideas here? How do you know if something is high quality? So anybody, if you want to take this and run with it, build on it, make it better, go for it. Yeah, it's available for you. So just as an example, if we were to click that little plus button and look at the questions for number 1, how was foundational validity established? It's questions like this. Did the practitioner provide evidence that the performance of the method or process they used has been measured? The last one, does the practitioner demonstrate relying on measures with generally favorable measurement properties? And lots more. There's 117 of these questions in here. How did this come to be? So we, in April of 2020, there was Canada's worst mass shooting. There was a mass casualty event that involved the death of 22 people and the injury of several more in an area of Nova Scotia, a small, relatively rural area of Nova Scotia. This was a huge deal for many reasons. And what happened and what unfolded crossed into a 2-day period and involved the impersonation of a police officer by the perpetrator. And there were a variety of issues with regard to the security of public safety. And so Canada has been looking forward to, and Canada does a good job of this, figuring out how to learn from mistakes of the past and figure out how to move forward. So that's the background of this. In this particular case, there was a psychological autopsy that was performed in the aftermath of the shooting. The perpetrator died at the sort of culmination at the mass casualty end. He died. And then the RCMP is the Royal Canadian Mounted Police, and they have a profiling unit or something. They have a group of people who do some psychological work, and they had a psychological autopsy done by that group about kind of the mental state of the perpetrator. And then this is a video that I'm going to play, and hopefully it works. It's about a minute or two. This is the superintendent, one of the superintendents of the RCMP talking. This is a press conference that was held in the summer of 2020, talking to the public about this particular psychological autopsy that later we were hired to evaluate the quality of. If you guys can't hear this, please let me know.
In terms of attempts to understand the motivations of the gunman. In an effort to better understand the gunman, why he committed these horrible crimes, and determine if there were any predictable factors which may assist in preventing future similar tragedies, RCMP profilers and an RCMP forensic psychologist from RCMP National Headquarters Behavioral Analysis Unit have provided valuable assistance to the ongoing investigation. This assistance includes a psychological autopsy of the gunman, and this autopsy is ongoing. The aim of the psychological autopsy is to gain a better understanding of the contributing factors to better comprehend, if possible, the why now, and why in this manner. Behavioral analysts have shared some of their preliminary findings with the investigative team. In those findings, the gunman was described as what is called an injustice collector, one who held on to conflict or differences with others, turning them inward until they boiled over in rage. Some recipients of his wrath of violence were targeted for perceived injustices of the past. Others were reactive targets of his rage, and some were just random targets. We may never uncover all the details or fully understand why the gunman did what he did. The investigation is committed to providing answers to the victims, the surviving family members, to the public that we serve, and to hold anyone who played a role accountable in these horrific crimes.
So in the aftermath of that mass casualty, there was a lot of public concern about how things unfolded and worries about, how to prevent a mass casualty in the future, and also how do you identify somebody who's a threat to public safety. And so there's a huge commission that Canada has pulled together, and it's a joint effort by the government of Canada and the government of Nova Scotia. So together they've funded this independent commission that's still, they haven't quite finished up, but they're looking at lots of pieces of what happened and how to move forward. As one piece of that, they were looking at the quality of the psychological autopsy. And so Christy Martyria and I were hired to evaluate the quality of that report and help Canada figure out, how to evaluate the quality of psychological evaluations that might be used in some kind of legal context, and so forth. Christy and I were careful and thoughtful about how we did this. So we didn't just look at the report. We actually didn't know much about the case at all. We decided and we talked with the commission. We said, if we do this, the way we want to do this is we want no information about the case. We don't want to see this report. They called it, the commission, as they were talking with us about whether we would do this work, they called it both a psychological autopsy and a behavioral profile. And those two things sounded like different things to us, but the commissioners were saying that this report that's what it was. And so we didn't want to look at it. We wanted to think about, in the abstract, what would a great psychological assessment look like in a forensic kind of context. And then after we did that part one, that was the abstract, these ideas and not the specifics of any case. Then in part two, we had the commission give us that psychological autopsy in question, and we applied the framework we developed in part one to evaluate the quality of the actual psychological autopsy in part two. These reports are also publicly available on the Mass Casualty Commission website. So part one was this: we developed, pulled literature together to identify these 8 best practices. We started at the general level and then we moved into the specific level. Part two was applying that framework and applying those questions, what I showed you on the OSF. We started with 108 questions before we saw the report. And then once we saw the report, we realized we didn't have all the questions that needed to be there. So we added more. It's now 117 questions. But anyway, we use those to evaluate the quality of the report in part two. We also, Christy and I, independently read through the report, used those questions, rated those things. We looked at our inter-rater reliability on how we evaluated the quality of the report, came back together, resolved differences in our coding, and then wrote our part two commission report based on that process. So I'm going to play you one more video, and then we'll get into the specifics of the 8. This snippet of the video is our testimony. It's the last question that we were asked on direct examination before we moved into cross-examination. So this is the one of the attorneys representing the Mass Casualty Commission asking us to talk about, like, what's the big picture of what we were trying to do here. Then this video is also publicly available on the Mass Casualty website if you're interested in seeing any of this. I will note that we did face a serious cross-examination after this about whether what is done in police work, whether behavioral analyses and whatnot that's done in the context of law enforcement work, if that's forensic, and if these should even apply. It was a great cross-examination, and it's worth maybe checking out if people are interested.
Okay, and I'm just about done. I just want to ask you one more question, because I've tried to ask you a series of questions to sort of walk through this report that you've provided to the commission. But I just wanted to give you an opportunity, if you had anything you feel like I haven't given you an opportunity to share with the commissioners and the public within the context of our discussion today and your identified expertise. I just wanted to give you an opportunity to respond to that.
So I think in the process of providing this report and distilling these 8 best practices, I think I would just like to emphasize how many people and authoritative organizations and critical scholars have pointed out these issues and have flagged their importance. And I think it's important for the profession and practice of psychology that psychologists are mindful of and aware of these best practices, but also that the consumers of our report hold psychologists accountable to these best practices, and that they have an expectation that psychologists will be doing their best to present the best evidence, and that includes considering these factors.
I also think, as I mentioned, part of our goal, I think, with our careers is to improve the quality overall. And part of that is to offer tools to help psychologists improve their work, but also to help the public and so forth. Like, how do you hold a psychologist accountable? Like, we're trying to, I think, aim at that question, even with the documents that we've provided in this case. So those 108 questions that turned into 117 questions is aimed at this goal. So we might hope that if the commission in its process, like sort of a forward-looking, what's the outcome of a commission like this, our contribution to that forward-looking approach would be to think about how a system might hold a psychologist accountable. If there are systems, if systems don't have processes in place to hold psychologists accountable to the quality of their work, maybe they could. There might be a better way to sort of require some best practice elements as part of a psychological assessment.
Well, thank you. And
Okay, so now we're going to turn into the actual 8 best practices. But on our way there, I want to tell you a little bit about the framing and kind of how we got there. And also this involves kind of what Christy brought to this collaboration that was different than what I brought to the collaboration. She's been doing a lot of work in the forensic science space with regard to serving on some kind of big US-based federal level efforts to try and fix some of the problems with forensic science evidence. And so she was bringing some of that expertise into this collaboration, I think, in ways that was really thoughtful and is beneficial to our field of forensic psychology. So forensic science is a broader field. It's a transdisciplinary field that involves a generation of scientific knowledge and the application of science to assist matters of law. This framing, this understanding, this definition is coming from the National Research Council, a big interdisciplinary federal level group. And then the PCAST as well. PCAST is the President's Council of Advisors on Science and Technology. They had a big report in 2016. The 2009 NRC report basically said there's a lot of problems with forensic science as currently constituted in the world and in America. We need to do better and improve things. And here's some ideas for what we might want to pay attention to. PCAST said that some things have gotten better with forensic science, but a lot hasn't gotten better and things still need to improve. Here's some ideas for moving forward. Forensic psychological assessment, we know this, but in general, we are psychologists, and as such, we are part of a field that endorses the norms and values of science, and we benefit from the esteem given to scientific endeavors. There is plenty to talk about with regard to that particular issue and argument, but in society, this is big picture what's going on. Also, there is pretty strong agreement that forensic psychological assessment should apply scientific methods and knowledge. We should be trying to do this. Again, I alluded to this there's a lot we could talk about with regard to whether psychology is a science. The answer to this is complicated and it's different. It depends on the agency you're talking about how they define psychology, how they fit within the policy priorities of different agencies. We can kind of sidestep all of that and say it doesn't really matter. We argue these things apply because in society, psychology does benefit from the esteem associated with science. There are well-documented concerns about the scientific foundations of several areas of forensic science practice. These concerns map on to issues that are also present in forensic psychological assessment. Therefore, solutions that are aimed at forensic science could be useful to help us improve forensic psychological assessment. So we're relying somewhat on that framework that was provided by the National Research Council and by the PCAST to provide a benchmark for best practices in forensic psychological assessment. And the two core ones that are coming from these documents are the foundational validity and validity as applied pieces. These are two of the best practices in our paper. So foundational validity has three pieces to it: accuracy, repeatability, and reproducibility. And then validity as applied has two pieces that we might think about: proficiency and field validity, and we'll talk about each of these. Our position overall, and sort of the foundation of the argument that we're building here, is that when a psychological assessment is provided in a legal context that relies on the norms, esteems, and values of science, these 8 best practices should apply. We know there might be different views about this. We understand that, and that is legitimate. We also understand that there are other types of professions that offer forensic assessment services. Psychiatrists do work in this space, social workers do work in this space, and so forth. Some of these best practices could still apply, right? These are not necessarily exclusive to psychology, but some of the specifics would differ. So for example, if we get into the specifics of the ethics guides and the practice guidelines, those will differ somewhat by profession. Also, one more note, kind of before we jump into the specifics, the law is pretty clear that the evidence rules apply. So even if a psychologist were to say something like, what I'm doing is not science, I'm doing something more akin to medicine, I'm using my clinical judgment and I'm not using scientific methods, therefore all this best practice stuff, and especially, all this stuff might not apply to me. The evidence rules, at least a piece of some of this that we're talking about, the law has already said clearly these apply to you even if you say you're not doing science. One more note I wanted to reiterate. These 8 are already established. We didn't invent them. The issues we raised have been raised by others over decades of critical scholarship relating to psychological opinions in forensic contexts. And similar questions have been raised to evaluate the quality of traditional forensic science opinions that don't have anything to do necessarily with psychology. So we're pulling these things together, but none of them are particularly new. So best practice number 1, we'll get into specifics. Foundational validity, according to the PCAST, is the foundational validity of a method or process requires that that method or process be shown based on empirical studies to be repeatable, reproducible, and accurate at levels that have been measured and that are appropriate to the intended application. So foundational validity then is whether the method or process in principle can be reliable. There's some issues as we start to think about how that would apply to forensic psychology. So first of all, in our field, we don't have standardized assessment protocols. Some jurisdictions do for particular issues, but on the whole, we just, as a field, do not have standardized assessment protocols, which raise some questions about foundational validity. This tremendous diversity of approaches that we have in the field, I think, and would argue is a problem for establishing foundational validity. If we shift gears a little bit and we're thinking about individual assessment tools, we are better. We are looking stronger with regard to foundational validity. We have some assessment tools that have good foundational validity foundations. I don't think I can say foundations as part of foundational, but anyway, hopefully my point is clear. I would still say though that saying we have tools that are foundationally valid and in principle, you know, have these features, it's still not a viable substitute argument for lack of protocol standardization. So for instance, if we're saying if the referral question is something like mitigation for a death penalty context, what is the characteristics of this person that might argue for a sentence less than death? That's a referral question for which there are no clear individual assessment tools that can answer that question, right? We might use an IQ test, we might use a personality test, we might use, who knows, we could use things that have good foundational validity, but whether we can do them in a way that can answer the forensic question in a foundationally valid way is a different thing. Accuracy, so now we'll talk kind of about these three pieces of foundational validity. One, accuracy is how often a method or subjective reasoning process results in a correct opinion or outcome, which I am confident all of us in this space are aware that this is not, it's maybe unknowable in forensic psychology. Still worth thinking about in principle what this would look like. So there is no ground truth to most of what we do. For instance, when we do, when we reach an opinion or we testify to our findings, oftentimes what we say influences what the ultimate decision in that case ends up being. And so these things are not independent. Anyway, there's lots of issues with regard to figuring out foundational accuracy in our field, but there are some things we can know and some things that some assumptions we can make about this as related to our work. So generally, I think that it's reasonable to assume that assessment of current functioning is probably more accurate than trying to assess past or future mental states. And those things have some relevance to considering this accuracy issue. Also, I think we as a field could agree and have evidence to suggest that structured actuarial methods are generally more accurate than unstructured clinical judgment methods. There is a lot in that statement that we could unpack. We could spend hours talking about that. I think the sentence as structured there probably is, it could stand. And then also we can consider the impact on accuracy when we think about generalizability issues. So even if we have a tool that has good psychometric properties and in principle can be foundationally valid, it still matters how it's used and whether the situation of the case fits the foundational validity possibilities of an assessment approach. The second of the three for foundational validity is repeatability. This is the idea of intra-rater reliability. This is whether a method could consistently produce the same results when used by the same person under the same circumstances. So ideally, we would be able to do this. We don't have a lot of data about this. And there's practical reasons why we don't have a lot of data about this. But we could, if we as a field wanted to put some of our research attention to answer a question like this, we could think creatively about how to study this problem. But it's not an easy problem to try and study. Also, just as a note, if any of these, I'm going over these very quickly and not getting into depth on many of them. There's more grist to think through in the paper. There's plenty of room for discussion on all of these things. So just know, there's a lot more to all of this than what's on these slides. And then the third of the pieces of foundational validity, this is reproducibility. Otherwise known, we might call it inter-rater reliability. This issue has gotten a lot of attention in the open science world. How do you improve the credibility of scientific claims? How do you interrogate the quality of scientific claims and whether two different groups of scientists are going to reach the same conclusion on the basis of the same evidence? Things like reproducibility become very important, and transparency in the process becomes very important. So reproducibility concerns whether an approach consistently produces the same results when used by different people under the same circumstances. If an assessment method doesn't lead to consistent conclusions when used by different people, then the foundational validity of that thing is undermined. So again, arguably, the more unstructured, subjective, adaptable, intuitive the method used by a practitioner, the less likely that another practitioner is going to be able to come to the same result and conclusion in that same case. And this concern is also reinforced by some evidence in the field that practitioners can use different thresholds for determining a range of forensically relevant outcomes. There's a lot here. There's a lot of room for improvement here, and some of this is easier to study than some of the other things we've been talking about. And some people have been doing research in this area, really good research in this area, but this is an area that if people are looking for somewhere to pour some time and effort into doing some work, I think there's good opportunities in this space. Okay, best practice number 2, validity as applied. Now this is when there is a foundationally valid method, when in principle it could be reliable, then it is, or it could be accurate, then validity as applied is whether it was applied in the right way. So it's the accuracy, repeatability, and reproducibility of a method in practice. So in particular, the forensic examiner must be capable of reliably applying the method and must actually have done so. So we can think about this from 2 perspectives. We can think about the proficiency of the practitioner, and we can also think about the field validity of the tool and the approach that undergird the assessment itself. So on the proficiency side of things, a practitioner's ability, if a practitioner is to be proficient, that means that they are able to apply a foundationally valid method or tool to come to the expected outcome for the method itself. And that is ultimately an accurate opinion, which again is very hard. This is not an easy problem to solve, especially in our field. But if we are thinking big and what this could mean, this is what it could mean. If we aren't able to do this as a field, if our practitioners cannot do this, then arguably we would have some issues with proficiency in the field among our practitioners. If the field could do this, but we're looking at individual practitioners and whether they can do what the field can do, then is this person able to use what the field can do in a good way? Can they do it in a good way that's consistent with what the field can do? If they can't, then they aren't proficient. Their opinions aren't valid. They shouldn't be admitted in a court of law. I'm going to skip the last piece. Proficiency is often assumed by virtue of formal education, certifications, qualifications, memberships, continuing professional development, but the relationship between these things and proficiencies is definitely imperfect and it's often unknown. Some credentials do require demonstrations of relevant proficiencies, but many do not. So as we're thinking forward about how to improve the field, some of these things we could pay close attention to. It is overall, again, as I'm saying, all these things are hard. This thing is hard. It's difficult to establish the proficiency of practitioners completing forensic psychological assessments. We could take an estimation approach with mathematical modeling. Some people have kind of done something that we could use as a parallel process, but failing that, information about consistency and bias or performance on tasks replicating casework could also be used to estimate proficiency, and people are doing some of this work in really interesting and important ways. And also, just as a sort of overall note, direct demonstrations of proficiency are always preferable to indirect estimates by proxy measures, but the direct demonstrations are often very hard, if not impossible, to actually do. Okay, the second piece of validity as applied, field validity. This relates to the performance of a tool or a method outside the lab under practice conditions that are typical of work in the real world, where information might be inaccurate or incomplete, assessment conditions might be suboptimal, cases might be more complex or confronting, and time or financial resources might be limited. Overall, we don't have a lot of data about the field validity of our methods as used by practitioners in the real world, but what there is suggests that there's reason to think that there's a reason to be modest about this. John Edens and Mark Boccaccini had a special issue kind of targeting this issue a few years ago that was really good. And there's still plenty of work that could be done in this space as well. Just quickly, I'm going to go through this quick, but I wanted to point out why these things matter. Like we're still kind of talking in this esoteric, abstract idea space, but these things matter. So the Supreme Court of Canada in 2018 had a big case, Ewart versus Canada, where basically the argument was an Indigenous man who said a psychological assessment that used tools was made to use decisions about me, and that was the validity is in question about that because people like me weren't part of the normative sample of the tool as it was developed. And the Supreme Court of Canada said this is an argument that has legs. So as a field, we have to be thoughtful and careful, one, about how we develop the foundational properties of a tool and what's out there that practitioners could then lean on when they decide whether to use a tool. But then if you're deciding to use a tool, really looking at those properties of the tool and whether it's appropriate in the case is very relevant and important. There was a similar case in Australia in 2007. Karen Franklin has an awesome blog. She has one particular post about this. And basically the big picture is the same, that there was an Indigenous person who said this risk assessment didn't have people like me when they were developing it, therefore it shouldn't be used to make decisions about me. And a big court in Canada agreed with that argument. So this issue of field validity matters in the real world. And also there's another piece of this that I wanted to mention, and that is the issue of tool combination and batteries of approaches. So even if in our field, even if we have relatively robust tools with good psychometric properties and that are foundationally valid assessment methods, we routinely combine them with other tools in countless unstudied ways to form assessment batteries. And these are highly individualized. This issue that I'm pointing to is known. It's an issue in psychology. It's not just an issue in forensic psychology. This is something that is a challenge for the foundational validity of the field of psychology in general. Yeah, I'll end there with that. Moving into number 3, management and mitigation of bias. Bias is in the way that I've been thinking about it and talking about it with many of you over time. It's this idea that bias is any systematic factor that could affect our judgment other than the truth, like what should be affecting our judgment. Lots of things can affect us that aren't truth. And if it's systematic, then we can think about it as bias. Whether we mean to have it affect us or not, doesn't matter. And these kind of things can affect our judgments on a continuum of cognitive processing. So it can happen when we're engaged in low depths cognitive processing, where we're like not paying a lot of attention or heuristically processing things, or emotional time pressure, is making us skip detail, whatever. Like we can be in that kind of space, or in a much more deliberative, careful, explicit kind of thinking. Regardless, bias can still affect us wherever we are on that continuum. Bias has also been identified as a concern with forensic opinions more broadly. This is not, this is an issue that affects human beings, and therefore, anytime there is a judgment process that involves human judgment, the possibility of bias is present in that environment. There's no evidence that forensic opinions provided by psychologists are exempt from bias, and in fact, there is evidence that we are human and subject to bias like other humans, which is good news in some ways that we are human, but it also means that we need to think carefully about how to structure our decision environments to try and protect against those things. Given that in our field, we collect and incorporate extensive collateral and contextual information, we have few standardized procedures that guide our field, our opinions are perhaps particularly vulnerable to some of these biasing effects. This is clearly an area where we can do some things differently to improve the quality of what we offer. I've been thinking about working in this space for a long time. I had a paper coming out earlier this year, kind of chewing on some of these ideas. And the idea here is that bias can affect us regardless of where we are on those higher or lower depths of cognitive processing. Like we can't escape it no matter where we are in our thinking, but we can use various methods to get to this on the susceptibility to bias on this chart. We can use different strategies to get us in that space where we're less affected by bias in our judgments. I'm not going to talk a lot about that here today, but this is something that I do think a lot about, and I think we have plenty of room to move forward on some of these ideas. Number 4, attention to quality assurance. There is a whole world out there. There's a whole field of quality assurance. I had heard this, but I had never thought about it in the context of forensic psychology. Christy, this was another one of these areas that she brought to this collaboration and this conversation in ways that was really useful. And this is happening in forensic science. So there's an international international organization of standards, and lots of bodies that are kind of working on ideas like this. Basically, quality assurance is administrative and procedural standards to prevent mistakes and avoid problems in service or product delivery. Many industries in the world rely on quality assurance models, but we don't have these yet in forensic psychology. Some jurisdictions have some version of quality assurance informed standards and so forth, but as a whole, our field isn't thinking in this space. This is a clear opportunity for us to do something different. As we think about quality assurance and what we already do have, we have licensing requirements. These vary by jurisdiction, and they are a form of quality assurance for psychological practice in general, but licensing boards typically don't govern specialty practice. So with regard to forensic psychological assessment, it's something, these licensing requirements are something, but we could probably do more. Psychology and forensic psychology, we have ethics rules, we have codes of conduct, and these things are also relevant to quality assurance, but often these are aspirational. The enforceability is limited, and there's no actual quality assurance in this. There's no comparison against an ideal or target outcome. There's no feedback loop built in. In response to concerns about poor service quality, many jurisdictions, including people in this room and who have talked in this seminar, there have been quality assurance relevant things that we have done in this field, like training, certification, credentialing programs to try and deal with and target this particular issue. And some of those are going really well. So the field can do this. Maybe we can do this in a more robust manner together. So for example, Neal Goensmith and team had a paper in 2015 looking at finding that 19 US states had specific programs for training and certifying mental health professionals who do evaluations of competence to stand trial. This is in the spirit of quality assurance. Some of this is happening. These programs do differ substantially, and most of them aren't built with robust quality assurance aims. But jurisdictions with better quality control procedures do have higher quality forensic assessment reports overall than jurisdictions without these kinds of programs. Also, we have this board certification process. Psychologists can voluntarily seek board certification by the American Board of Forensic Psychology, which does involve some quality assurance processes like verification of education, relevant training, licensure experience, and demonstrated competence. And there is evidence from real cases, empirical evidence, that on average, board certified forensic psychologists conduct higher quality evaluations than psychologists who aren't board certified. But if we're thinking about how to move forward as a field, we can think about quality assurance processes as a way to maybe do some things together moving forward. So the National Research Council had this kind of thing in their report talking about how a field could move towards standardized vocabularies, ontologies, scales, written exams, supervised, all kinds of things. There's a lot here. We have this, maybe the strongest statement in our paper, and I wanted to share this with you guys because I think this is interesting. Organized forensic psychology should take on the task of establishing guidelines for various specific forensic pursuits, such as in the spirit of APA's guidelines for custody evaluation, dependency evaluation, and occupationally mandated evaluations. And accompanying quality assurance implementation procedures could be developed to move the field forward. Ideally, these task-specific forensic psychological assessment guidelines would carefully consider the 8 best practice considerations detailed here. Plenty of room there for anybody, I think, who's interested in doing something in that space. Best practice number 5, appropriate communication of data, results, and opinion. This is well-trodden ground in this group. We have great books and resources in our field about this. Clarity and transparency is vital for expert reporting. Logical, coherent, and transparent reporting structures aids in audience understanding. Every source we use should be labeled concretely and identified clearly. Transparency, this is important. There's a reason this is an ideal, a best practice that we should strive toward, and that is that understanding and being able to evaluate what information the assessor had and didn't have is critical to evaluating the quality of what they've done. Because one clear source of unreliability and bias in expert judgment is when people are forming opinions based on different information. So if you know what information they had and you're comparing experts or something, then you can know that that's relevant to potentially how they reach their opinion. Referencing is a thing that this is important. This is a fundamental component of communicating scholarly and scientific knowledge. Citations link data, results, theories, and conclusions to their epistemic foundations. It also allows readers, consumers of the report, to access and evaluate original sources that are underpinning an argument. We don't need to cite everything in our report, but we should have some sources in there, especially for the strongest things that we're arguing or whatnot. This, at least in my jurisdiction, to date, is sometimes discouraged, but this is something that I think is important anyway for us to be doing because it's just part of our scientific and scholarly foundation as a field. One more thing about this, and I think we're moving forward to the next best practice, and that is facts and inferences have fundamentally different properties, and rigorous reports clearly separate them. Data and inferences should be reported separately. Data should precede inferences and opinions. Inferences and opinions can build on earlier data, but no new facts should be introduced in an inference and opinion kind of section. Rigorous reports acknowledge room for doubt where appropriate and don't exaggerate or understate the certainty of an opinion. Unqualified definitive expressions are scientifically unsupportable. If we're doing that in our reports, this is something that we need to try and not do. Best practice number 6, explicit considerations of limitations and assumptions. All psychological opinions are based on some set of assumptions and inevitably have limitations. Everything has limitations no matter what we do. These limitations and assumptions, we should be clearly characterizing them in the reports so that the consumer of our work can see us, can see what we're arguing, can see this space we're operating in, and can evaluate the quality of what we're offering accordingly. We can help our audience understand the limitations of what we're offering by disclosing information about adherence to these best practice recommendations. So in the report, we kind of go into each of the 8 of these and how you might think about discussing or having a small, depending on how your report looks or what the case is, these things could be addressed in the report. And this would aid your audience in understanding and being able to evaluate the quality of what you're offering. Assumptions and limitations shape the scope and nature of our opinions, and they affect how people should weigh and rely upon what we're offering. So it's important that we provide explicit information about limitations and assumptions and ensure that those are understood, that the audience, the consumer of our report, can understand what we're saying about them. They might not do it, they might not pay attention, but the onus is on us to make sure it's there. Weighing best practice number 7. Understanding how the opinions of the practitioner differs or aligns with mainstream or best practice ideals is really important for the consumers of our work to have in order to evaluate what we offer within the context of our field. Scholars and philosophers of critical thinking have highlighted that it's important for somebody who's listening to an argument, they need to understand what the assumptions are of the person who's making an argument. They need to, they need the bigger picture of what's going on to evaluate the strength of that argument. I'll move forward. This is the other strongest statement in the paper that I think is worth thinking about. Importantly, the failure to acknowledge areas of professional disagreement shouldn't be taken to indicate their absence. That is, absence of evidence shouldn't be taken as evidence of absence. Instead, such omissions should lead to questions about the technical proficiency of a practitioner who's not aware of relevant contemporary critical discourse. We do, in the paper, we go into some specific examples. We do not have time right now for me to go into specific examples, but we could talk about those. Finally, best practice 8, adherence with ethical obligations, professional guidelines, codes of conduct, rules of evidence, and so forth. As licensed psychologists, we often have ethics codes. We also, if we're members of professional organizations like the APA, for instance, we have some ethical obligations. But unlicensed practitioners who nevertheless might be doing forensic consulting are not, and who are not members of professional organizations like the APA, there may not be formal ethics rules that are operating in that space, which also has relevance to what we argue is forensic psychological assessment, sometimes happening in police contexts. Some scholars have proposed, and including the National Research Council, has proposed that there should be an expert witness code of conduct for any type of expert who's operating and swearing into a legal proceeding to address this gap, that it shouldn't, that this problem shouldn't rest just on the professions, that it should be a different angle on the same kind of problem. And also some jurisdictions are doing that. That's happening. New South Wales, one of the states in Australia, they're doing this. They have a code of conduct, which could be working, it might not be. It's an empirical question. All right, so in summary, our intention is that these best practice considerations and the supplementary resources we're offering, we hope that this has practical application and benefit. These theoretically informed best practices should aid in evaluating quality, value, rigor of forensic psychological assessments. And we hope that reliance by both psychologists and the courts on these best practice ideas could improve the future of forensic psychological science and practice. Some references, there's an evaluation link. I'm sure it might go in the chat, but I will stop here.
Outstanding, Tess. Thank you very much. We do have a number of questions, but let me make sure everyone knows that Alex has posted the link for people to get their CE credit now for this presentation. Those of you who have been with us for the hour can, all 520 people, well done, Tess. Well, you can log off and get your credits, or we're going to go through the questions. And Tess has agreed to stay on a little extra time to make sure we can address them. Let me pull them up, Tess. The first one, they want the Excel spreadsheet and the link for that. Is that workable? I can't hear you. You're muted. It's all right.
Shoot, sorry. Yes, I will definitely put this link in here.
Okay. All right, question, how does the 117 questions impact the practical writing of a report in relationship to being manageable in terms of size for the writer and the receiver?
It's a great question. I don't know the answer. And I think this is the time, like if as a field we're going to be, and I don't know as a field if we're going to be moving on any of this, but if this is the time that in the field we want to move on some of these ideas, this is exactly the kind of thing we have to think about. Like logistically, how could this actually work? And right. I don't know. Like I think that in my jurisdiction, I am clear that the court doesn't want a long report. They want my opinion on page 1 and maybe nothing else, right? That's not, I mean, even if the court wants that here, to me, that signals that there's some education that needs to be done in my jurisdiction to help the courts understand why that's not a great expectation for my field or any other field that's bringing forensic evidence into court. I think that has changed here. I don't think that's the expectation anymore. But when I first moved to Arizona, that was it. We want your opinion. We don't want to hear anything else. And also in terms of the incentive here, which is different in different jurisdictions, the incentive here, for instance, we have a contract process with Maricopa County. If you want to be doing competence to stand trial reports, you have to go through this particular training and then you get in a contract, and no matter what you do, it's a flat fee of $300. You will get a fee, you will get a payment of $300 for your report. So the incentive is clear in my jurisdiction to not do any of this, to write a 1-page report, submit your opinion, get your $300 and be done. That's a problem for quality, but it is currently how the incentive structure is set up. So I think that's a great question.
Yeah, I think it's a great question too. I've always felt that the longer the report, the less likely you are to have somebody actually read the whole thing.
Which is okay, maybe they don't have to. Like if you're communicating clearly, here's where I landed, and you're
Right.
providing all the way you got there, I don't think it doesn't matter if people actually read that, but it's there if they need it, if they want to read it, if somebody's doing their job. Like that's my position on it. That's how I also approach my scientific work. So on the publishing side of all this, the same conversations are happening. So why should scientists be doing pre-registration? Why should they be posting their data? It's opening them up to criticism. It's slowing down the research process. Same conversation happening in a totally different parallel version of how things should unfold. And the answers are not easy.
No, great answer. The question is, I'm not sure this is appropriate for the presentation. I've read it, I think it is. I'm curious as far as the best practices are concerned regarding forensic psychological evaluations. What would be your opinion regarding whether someone should opine about the quote degree of psychological certainty, end quote, that conclusions in a report should be relied upon by the reader, so that statement leads them to a conclusion that may or may not be sound? Those are my words.
I didn't follow the question. My brain was not catching up. Can you ask it one more time?
I think he's asking, or she's asking, it's a he in this case, that if somebody writes in a commentary about the degree of psychological certainty, and so that leads people to a conclusion that may be wrong because that's a loaded line, right? I mean, so I think that's the question.
Yeah. So I think some jurisdictions require a statement like this, and the National Research Council has been chewing on this problem. And in our paper, in that, I think it's best practice 5, that expert opinion piece of it, we also talk some about this question. And basically, and I think Randy's position, he might totally want to correct what I'm saying here, but I think his position is that that's bunk, that right now we don't have like a statement like with psychological certainty, I can say this thing, or if that's what this question is. That's right now, we do not have the kind of standardized vocabulary where that would have the same kind of meaning for all people and for listeners who might be hearing what we have to say about that. I think there is a kind of standard template statement that's in a lot of reports that has something to do with this. But I don't know enough to answer well, I guess. And I think that there's reason to have conversation about this too.
Okay, let me do the next one then. Don't you think that the lack of standardized protocols relates to the fact that we're evaluating individuals and they don't all need the same tests? If you're giving unnecessary tests, that is potentially an ethics violation of its own. What if you do need additional testing? So I think it's talking about we need to be flexible.
Yep. And yes, and this is a great point as well. I think it's possible that as a field, we could figure out for this kind of referral question, if the referral question coming from the court is this person competent to stand trial? We as a field could figure out what's the baseline first way we would approach this. What's the best way to do this? We also don't want to stifle competition, right? So we don't want to say this is the tool that should be used, because then it would disincentivize there to be development of new tools. But like we've got to figure out some way to, right now the situation is the court could hire anybody and they're going to get something totally different and probably with low inter-rater reliability between us. And because we all use different approaches, like we may not get to the point where it's ultimately all standardized and it's no discretion and no flexibility. We probably shouldn't get there, but we could get closer to there from where we are now. And that might involve some like in almost like a decision tree. Okay, so if you're starting here for this kind of referral question, here's the default of how you should start. If there's a situation where X is happening, maybe go this route in terms of the process of how this kind of evaluation might unfold. And we could do something like that. We could try to do something like that for a variety of referral questions. And I'm with you that I don't quite know if it would work or if it would be worthwhile, but I still like thinking about it and imagining how it could possibly work and make things better.
Yeah, I think you run into a lot of people saying, don't tell me what to do. which is always a problem with people who are trying to answer individual questions. One quality assurance procedure might involve audio and video recording of evaluations or portions of them. Do you have thoughts about this?
Yeah, in my opinion, I think more transparency is always better. I know that there is competing issues. So sometimes there might be Fifth Amendment reasons not to have something be transparent widely beyond, but I do think it's nice to have a record. And so if there are questions about something that the way you got to the answer you got to is you can trace your work, you can show your work, right? Maybe nobody wants to see your work, but in my opinion, it is worth having the record of work behind you. And the recording thing is, it raises various issues, but if I'm just thinking from the perspective of showing your work and keeping your transparency intact, then that would be reason to do it.
Great answer. This question is more generic, but I think it's an important question. One of the most difficult obstacles is eliciting the users of our work, attorneys and judges. Are you aware of a broader effort to develop a true interdisciplinary work between psychology and law? And I think we've had conferences actually based on that specific issue, but I'll turn that over to you, Tess.
I just put in here the link to the OSF page for the supplementary material.
Thank you.
This is, I'll just tell you, if you open up this page, there's like a little, I'm just going to show you if anybody cares really quickly. This is what the page looks like, this OSF page. In this little right corner, there's a little thing with 3 drop down. You can download. If you click here, it'll download. The view you get here is not helpful, but if you download it into Excel and then open the Excel file, that's useful. Okay, so with regard to this question, I think, and I'll tell you what's happening at ASU and what I've been trying to push here at ASU, and it's related to the bigger conversation about what is forensic science and how is that related to forensic psychology. I was involved in a team here at ASU trying to imagine the future of, like, how do you fix all the problems in forensic science that have been identified? And of course, because I'm a forensic psychologist, I'm thinking through the lens of forensic psychology, but in this broader, much broader conversation, interdisciplinary conversation beyond just psychology. And so ASU is now moving into this space. We just got an announcement last week that we're starting a new school in something called maybe like interdisciplinary forensic science, and psychology will be part of the school. And the aim of the school is, how do you get scientists and law and scientists of a variety of fields, including psychology, in non-science, so other fields too, like linguists and whatnot, like, you know, they're also offering expert evidence, and some of these same problems are going to apply, even if they're not science, if they're humanities, right? So that some of these things are big picture issues. So I think I think the question was about, how do you stimulate conversation that's not just among psychologists about this? And I'm with you on the idea of the importance of this, and I'm trying to do it, but also I would love to partner with anybody who has ideas, or encourage people to have ideas together that have nothing to do with, you know, over here. It's a hard thing to do, but it's worthwhile to do.
I think APLS used to have meetings between psychologists and lawyers and judges. Not sure we've done them recently, but they did, and I did attend them in the past, and they were useful interactions. Anyway, I think we just have one more question. The last question here is, I think, the same as the one you just answered. First, thank you for your effort in putting into the field. Second, having now surveyed so many different reports and practices from such a breadth of jurisdictions, have you seen any particularly effective practices by attorneys to recognize suboptimal practice?
Ooh, that's a good question. Programs wise, no, not necessarily at universities, but, you know, it's like scholars who are doing this, and law scholars who are doing this, who are talking to their communities in the ivory tower. But I know less about what's happening in terms of groups in practice of lawyers who are doing a good job on these things. I do think that there's an appetite for it. So there's an appetite for improvement, but nobody likes to be told that what they're doing, could use improvement. And so it's always trying to walk this careful line of how can we do what we're doing better, but still recognizing the strength in what we're already doing. Like there's a way to approach this with both of those motivations, I think. And there's the Judicial Conference of the United States just is trying to rework the evidence admissibility language to try and tackle the problem of the quality of evidence coming into courts. This is the problem is much bigger than forensic psychology in terms of the quality of evidence coming into courts. And so the court system in America, but also outside of America, Australia is grappling with this. Canada has grappled with this. Like, how do you create a legal rule and a legal structure to encourage good quality evidence and gatekeep out low quality evidence? It's a hard problem, and no jurisdiction has done it well. Every jurisdiction is struggling with this for a variety of reasons, right? There's a lot of ways that this is a problem and why it's a hard problem, and it will require a lot of different solutions working together toward a shared aim to make the quality of evidence better in court. So there is appetite for it from, that people are aware that this is a problem and it requires creative solutions. But there's a big gap between that reality or that recognition way up high and what's happening in the real world on the ground every day in courtrooms.
Yes.
Resource limitation, case loads, like there's a lot of reasons why attorneys might not have any incentive to pay attention to any of this. But I think we do the best we can and offer tools and resources and trainings. Like, I'm talking to as many groups of attorneys and judges as I can. And I think all of us could do that. We probably are doing that. Many of us are already doing that.
All right. I really appreciate that. Jonathan Gould posted that these conferences are between law and psychology are now occurring every other year. I haven't been to one recently, but they are there. And so that's good. I mean, the more we interact as professions, the better. Tess, I want to thank you on behalf of the University of New Mexico for taking the time for an outstanding presentation. It really, we only can get better with these kinds of talks. And you raised a lot of questions. We don't have answers for all of them yet, but I am strongly convinced we're getting better. We invite everybody to continue to attend these conferences sponsored by the University of New Mexico Department of Psychiatry and Behavioral Sciences. And so you all can link into the CE and get credit that way. And we thank you very much.